Good evening. Well, I was out and about today doing some productive adult things. In fact, I just realized I still had the beanie on from all that. Um, I've been meaning to get back to this channel for a little bit now. Still not completely back yet, but while I was doing productive adult things, um, interesting thing Came down. Uh, our friends in Bingham had some news today. Now, in case it's a little bit unclear what I'm even referring to, uh, at the winter meeting last and for quite some time, it's been there's been a situation with the Bingham County Republicans where they didn't follow their own rules. They didn't follow a lot of stuff properly, and it's really weird because they probably would have got the same result that they wanted had they followed rules, and so there's been this whole back and forth thing. And so there's been at least some resolution to it, but I'll explain that a little bit. But yeah, I just been doing things like and I want to be doing other videos and update stuff soon, and other video ideas like I have a box full of these, and I kind of and sometimes there's stories with these little credentials and badges and whatnot, and I want to do a video where I talk about the memories in each one. Also, one of the things I did today was these are superior to ramen. Wai noodles will always be superior to ramen. They're just about the same, but they're from India. But yeah, those were the things I was doing today. And, imagine in the middle of all that, you you get something unexpected. Not only is there a at least a partial ruling with the Bingham County case, because the Bingham County people are so butthurt about people calling them out on them not following their own rules that they sued the state party over it. And it wasn't the other way around where the state party sues somebody like with Tom Luna, when you have a failure of leadership at the highest levels there. No, it was the other way around. So we had Bingham County suing, and then the judge sided with the state GOP, which is really interesting. Nobody actually thought that would happen quite that way. So I'm going to bring up the news story, and then there's going to be a little bit of a legal document and whatnot, and I'm probably going to have to mention a little bit of the law in just a sec. But let's see if the transition will work properly. Okay, so here's a news story from out in East Idaho. Uh, Judge, Bingham County Republicans failed to follow state GOP rules in electing new chairman. And I like how this is worded already, because all those corrupt people who are in control of the Bingham County GOP right now, those including people like Dan Cravens. If you've watched videos of mine, you know why I don't like people quite like him. I mean, Dan Cravens was the dude that said people like me, and included me, saying that I want to hang black people because I advocate for jury nullification. No, quite literally, he said that. That was the that was the winter 2017 IDGOP meeting here in Boise. Yeah, I remember when somebody ascribes such a thing to you, you remember that. But anyway, so here's the story. Failed to follow state rules, and people like Dan Cravens were saying, no, we don't have to follow the state GOP rules. Yeah, you do. I have another tab just for that here in a moment, but we'll read the story. It's not that long. Blackfoot, Idaho, KIFI. A Bingham County judge released a decision in a civil case between the Bingham County Republican Central Committee and the Idaho Republican Party. Judge Darren Simpson, I might say why that name is important later, I might not, said Bingham County Republican leaders failed to comply with state GOP rules. Therefore, the election for a new chairman on the day in question is invalid. Bingham County, Dan Cravens, they spelled his name wrong, and Bingham County Chairman held an election to fill his seat after he resigned. Matt Thompson was elected to fill the position. And they would have gotten identical results had they just followed the timing rules properly. However, the Idaho Republicans said that the election was invalid as the seat was not vacant then. And Mark Fuller was actually pretty clear about this at the winter meeting, but I already knew the issue though is that you can only elect a chairman when there's a vacancy or a reorganization meeting happening. Now, a reorg definitely doesn't happen July 20 for one, and it definitely doesn't happen in an odd numbered year, which last year was 2023. Now, every 2 years, there is a reorg meeting for counties, legislative districts, etc. But this, definitely not any of those things. And Dan Cravens was still chairman at the time. Figures. Judge Simpson goes on to say the action of Cravens leaves no doubt that he ignored state law. Okay. Republican Party rules and Bingham. Now, it's the same action with all three of these things: state law, Republican Party rules, and Bingham's bylaws. Because, and if I'm going to make sure that it switches over properly here. Yep. Okay, now I'm going to scroll jump up just a little bit. Now, this is Idaho Code 34505. I actually had to deal with this particular law and some other rabbit holes that I went down last year with my big thing that was up in Chalice. But here's Idaho Code 34505, Powers and Duties of County Central Committee. The County Central Committee shall have all the powers and duties prescribed by state law. So it's already, do they call that self-executing? No, that's the other thing. But it's already, the law is already referencing the compendium of Idaho statutes and laws and regulations promulgated and adopted by state conventions, which that's a thing that they can do, or that's a really big. And this is an either or. This is not an and or. This is an either or. Either the state conventions or the state central committee, and it's been like that for a very long time. And not only that, but Dan Cravens even actually happens to know quite a deal about the state rules because he's quoted them before. And I think even some sections out of that very article that they're just blatantly ignoring now, conveniently. But that's the law. The Idaho statute says that, yeah, you have to obey the rules that the state level party hands down, promulgates, is the technical term. Now, going back to the article here, it also outlines this document, which I already have open in another tab. So we're going to look over this together because I haven't actually looked over this whole thing. I heard something about a partial blah blah blah, but I find this interesting that they have an executive committee in Bingham County because that's usually not something that's spelled out in county bylaws. They have, that is a modification that's usually made later at some point in years. But let's see. The executive committee of the Bingham County Republican Central Committee, which is interesting that they're making this distinction. Given that they're the plaintiffs, that's a distinction that the Bingham County people made, and Matthew Thompson. Interesting. And the plaintiffs, Idaho Republican Party. It's a good thing that they didn't mention specific officers because, yeah. they didn't want to. I guess they didn't want to pull a Tom Luna. And this is the case number: order granting in part. Now this is the part I'm a little concerned about, but order granting in part defendant's motion for summary judgment. Well, I guess we'll move on here. Statement of the case. Plaintiff's Executive Committee of the blah 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 and Matthew Thompson filed the above-numbered lawsuit against the Idaho Republican Party hereinafter in seeking preliminary injunctive relief, enjoining Idaho Republican Party from blah 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 permitting to continue to operate. Well, no, they can't, because one of those laws I just mentioned, and requiring Idaho to afford the due process is guaranteed in the. So they want the benefits of the rules, but none of the responsibilities of the rules. Somehow that just fits with somebody like Dan Craven's. Just saying. Oh, what's this? Where was the amended? Okay, this looks like oh, there's interesting. Apparently, there's some procedure that didn't happen, and that might have been on purpose on their part. It might be one of those things that they're entitled to legally do. Saying process is granted in the Idaho Republican Party rules. The Bingham County people, I'm just going to say it like that, also requested a declaratory judgment validating, validating their bad actions. I'll just say that, and that they lack authority under state law to void the election. Yeah, that might be technically true, but you could also just you wouldn't want to necessarily void the election. You just declare it invalid, which is probably the safer route to do. And requiring them to reveal the names of the complaints and all communicated regarding. Oh, they wanted to out the they wanted the whistleblowers. That's interesting. That's really scummy behavior, Bingham County. That's really scummy behavior. In addition, the Bingham County people sought breach of contract and breach of covenant in good faith and fair dealing damages. Yeah, that's weird how you would say it like that. Okay, fine. In response, generally denied and the claims and asserted. Of course, because that's a bunch of crap. They're just throwing something at the wall to see what's stick. And if you're an honest, honorable person, that's not exactly how you would handle things. But anyway, the Bingham County people requested and was granted a temporary restraining order on the whole thing to designate the because that is actually one of the things that county Republican Party will be responsible for, is to designate nominees for certain county level positions and whatnot. The BCRC's motion for preliminary injunction was later granted, for allowing to pursue its appeal, blah, 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 blah. Has a lot of interesting details in here about a lot of the the procedural back and forth. Motion, there's a lot of things in here, but the Idaho Republican Party now seeks a adjudication of the bad people's lawsuit. The Bingham County people opposes the motion, obviously, because they really want to drag this out. And this is really just this whole thing, by the way, was literally just a get Dorothy Moon thing. That's all this really was. A hearing was held on that thing based on the party's arguments, the record, and the relevant authorities. The motion for Idaho Republican Party's motion for it shall be granted in part and denied in part. All right, well, let's see what, because the news can just totally mix things up, and they don't get things right a lot of the time. But let's keep going. The Idaho Republican Party argues that the Bingham County people failed to raise a material issue of fact on any of its claims, and therefore summary judgment in their favor is appropriate. Okay, so we're getting that far. Now you have to build on stuff when you're in the legal system like this, and this isn't. And judges, when writing these things, are no exception. Specifically, the Idaho Republican Party argues that the Bingham County people breached its contract with the by failing to follow Idaho law, which I chiefly just mentioned, the party rules, and the Bingham County bylaws. Okay, let's see what that says. 15 right there. What's the 15? Oh, some brief that. Yeah, I'm not going to go hunt it down. The Bingham County people assert a factual dispute exists on whether the conditions precedent were met for to issue declaring the election void. They might have a little bit of a thing there, but I'll continue. The Bingham County people for the contends that a fact issue exists as to the contents of the contract and what those contents mean. Well, it's not so much of a bad question there, but you shouldn't ask it unless you know where it's going. Just saying. I'm just going to call that state party now because it's just getting anyway. State party replies that the state law and the state party rules govern the procedure to elect a new county, not Robert's Rules of Order. In fact, wait a minute. I think Robert's Rules even says this, and it's like near the beginning too. I'm going to see if I can find my copy of Robert's Rules real quick, because yeah, here we are. Yes, sometimes I read Robert's Rules in bed. Yes, I'm that much of a rules nerd. But that's it. It's near the front. I think it's near the front here. Let's see. I'm doing this live while recording. Okay, yeah, it's like in the front page here. If the bylaws specifically identify one of the 11 previous editions, it should be. Oh, wait, no, that's not it. It's near the front because I remember reading this at least a couple times. Let's see. There's this preface. Okay, it's not in the preface. Okay, no, we're still in the introduction. Principles, nature of the deliberative assembly, active meeting bodies. You know what? Actually, I'm still recording right now. Now let's see. I'm just gonna find the part where Robert's Rules mentions bylaws specifically. Bylaw. Okay, so it's chapter or section 2. Yeah, I'm still getting used to the new nomenclature of the 12th edition over the 11th. But in general, the society or the documents contain its own basic. In the ordinary case, it is now recommended that rules. Wait a minute. We don't even need to go there because they probably have a parliamentary authority clause in their own bylaws. So I'm gonna look something up here because of this is another win for the bylaw archive. One of my babies. So party resources, I believe it's still in. Scroll down. I believe I'm still recording here. Yes, I am still recording. So blah 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 blah. Aside from Numenor, state party decision. Okay, here we are. I should go through the state party decisions later. So we're looking at Bingham, all the way out there. So this was last amended 2018, looks like. It's usually a little bit down. A lot of these have similar structure. Okay, Article 9 of their bylaws. Okay, here we are. The rules contained in the Roman shall govern these proceedings in all cases which they are applicable and which they are not consistent with these bylaws. So there's already a problem for them. Idaho State Code. So that's a problem. That's a bigger problem. Or the Idaho Republicans or bylaws. I think they mean to say rules there. They were kind of referenced the same thing. Shall elect department. Okay. So they didn't even read Article 9 of their own bylaws. We're going to go back to... okay, so where were we? The chairman, not Robert's Rules of Order. The state party maintains that chairman properly rendered a decision on a grievance filed by aggrieved parties, hereinafter the grievance. State party assails the notice as to its chairman election. It's my understanding that they probably didn't do that. That's not the thing that'll take it down, I don't think. The state party takes a position that the chairman did not comply with state party rules. Finally, the state party asserts that its motion properly addresses all of their causes for action, and from what I've heard of it, that's entirely true. In addition, the state party objects to the declaration of Anthony Hanson, a fellow in support of... I'm not even entirely sure what that is. I have not heard of that. Let's see, 23, see, I am not gonna, I'm not hunting that down. No, no. Because besides, it's probably not relevant. Based on the party's position of the record and relevant authorities, the following issues come before the bar for adjudication. Is the Hafen Declaration relevant to the issues at bar? Has the state party shown the absence of material fact regarding the breach of contract? Okay, well, let's see. Has the state party shown the absence of material facts regarding the breach of covenant of good faith and fair dealing claim? Well, let's find out. Has the state party shown the absence of material fact regarding Bingham County's request for declaratory judgment? Maybe you don't want to pull on that thread, Bingham, but okay. Has the state party shown the absence of material fact regarding Bingham County's request to show cause to reveal the names on who filed a grievance? Yeah, and Bingham County, you should really not F around with that. Because if you're looking to find out names of whistleblowers, 1, have a good reason. 2, not be scumbags about it. And 3, and this is kind of them, can you be trusted with that information? So, let's get to the findings of fact here. 3, findings of fact. The Idaho Republican Party is an unincorporated nonprofit association organized under the laws of the state of Idaho and headquartered in Boise, Idaho. The state party is the governing body of the Republican Party in Idaho. That shouldn't be in dispute, but Bingham County, you may not think of it that way, but that's kind of what you're saying is, well, we can just ignore the state party. Well, no, you can't. Republican chairpersons serve on the, yes, along with others, but yes, that's true. The Bingham County people is known common nonprofits and acts as the Bingham County Republican governing body. That's supposed to be true. Let's see how well they're doing it, though. The Bingham County people advise the state party regarding the development of policies and functions. That's how it's supposed to work, but, curmudgeonly pockets of the state often get like that, especially if they disagree with the state party chair being a woman. And no, I don't throw that kind of accusation around lightly. I do not at all. I'm thoroughly convinced that a lot of the opposition to Chair Moon, duly elected Chair Moon, has more to do with her being a woman than anything else. People may not admit that to themselves, but it's probably exactly what it is. The Bingham County blah blah blah. The Bingham County people also implement policies and functions of, yeah, they're supposed to be acting under those rules. That's the whole point of those rules. And you're trying to say that no, that's not a thing. Yeah, it is a thing. Okay, a bunch of footnotes that we don't need to bother with right now, if ever. Continuing on or about June 15th, met an executive session. Okay, that's already a problem if you're talking about election. But okay, on or at which time Bingham County Chairman announced his upcoming resignation. Okay, it's not effective yet, I'm imagining, especially if you're looking to chair the meeting, Dan. But we'll keep going. On July 13th, so almost a month later, 1 week prior to the regular meeting, a chair sent out an email to their secretary, Ms. Cannon. In that email, Chair Craven said, in order to help pave the way for a smooth, it would be best to elect a new chair at our meeting at the courthouse. Chair Cannon sent the email on the same day, July. Okay. This implies that he already knew the problem with it and was trying to pull a fast one. That's pretty much what they're getting at there. That's interesting. Okay, so moving on. This thing doesn't scroll properly. At the July 20 meeting of last year, Chair Cravens vocally announced his resignation effective August. Oh, okay, so he knew that there was not yet a vacancy, much less enough time in such vacancy. Therefore, despite concerns voiced by certain precinct committeemen, the first line vice chair were elected. That's also kind of a procedural problem, because if you're, say, a first vice chair and you get elected to be chair, and then that means that you have to resign first. It's one of those technical things. Let's see. Oh, there's a footnote about that. 38 here at the bottom of the screen. Oh, okay. So this is something that they even admitted to? They're dumb. Okay, let's continue on. Thereafter, Chair Cravens moved to suspend the rules. Oh, okay. Story time. He knows better. Dan Cravens knows better. Because remember that story I just told about him referring to, saying that I just want to hang black people because I support jury nullification? Well, the circumstance was the resolutions meeting of the 2017 winter meeting, right? And so that's on a Friday. That was the Friday night there. There was some drama earlier in that meeting. Somebody else, and I don't remember what exactly they were even getting at or what their real motivation was for doing this, but somebody else in the room tried to suspend a certain requirement for hearing another resolution. Dan Cravens objected to this, and at the time, rightly so, saying, we can't suspend the state party rules or bylaws or anything like that. He said that. Pig-headed, round-faced, bitty, that's all face, said that. Anyway, the rules to elect the blah, 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 so to elect the Bingham County State Committeeman, youth first vice, third vice chair, which positions were vacated by the elections of. Oh, okay, so they were vacated, and so now you have a bunch of vacancies. Interesting. Offices. His motion was carried. Oh, see, yeah, you can't actually do that. The motion was out of order anyway, regardless of how people vote for it. down ballot position were elect. Okay. On July 20th. Okay, so this is a handful of days later. Let's see, this was all July 20, so this is, what, a week later. On July 27, 2023, the state party received a complaint hearing the grievance, alleging that the Bingham County people, chairman of a week prior, election was invalid. Let's see, 41, the footnote 41. Injunction order. Okay, so it's something that they mentioned at some point. The grievance also complained the rule suspension was for of the suspension and election of. Okay, I mean, you might be able to elect 4 people with the same vote. I mean, that really depends on how your bylaws are worded. Usually you can't, but you might be able to. But yeah, okay, there's a problem. So August 11th. So this is a little bit of time later. Executive Director Kira turned. Oh, okay. There's another thing that I have to explain here because it's probably not going to be laid out in this detail is probably not going to be laid out. I think this is right around the time where Kira is good people, by the way. She when something's in her wheelhouse, she can definitely get it done. I'll just say it that way. And I'd trust her with a lot of things. So this is about the time that she was how do I put this? I don't want to call it an injury, but she was dealing with an extremely personal problem to the point where it was probably tons more difficult to be dealing with all their crap, especially even with like emails and stuff. So this is right around that time where I think that stuff started happening for her. So, oh, great. So August 11 last year, Kira sent an email to Mr. Notifying and stating that investigation had begun. That's got to scare anyone. And requesting additional information. Mr. Verner responded a handful of days later on August 21. Okay, so a week after that, Mr. Thompson and other members of Bingham County received a copy of the grievance. Okay. The grievance asserted that several rules and bylaws were broken. I mean, they're not wrong, probably. Depends on what rules and what bylaws they're actually citing there, but they're probably not wrong. And therefore, Mr. Tong was not duly elected chairman. Specifically, the grievance complained that the chairmanship was not vacant when Mr. Thompson was elected. That's true. Points of order as to the chairmanship were rejected by good chairmen don't command, they serve. I keep saying that, and it keeps coming up. Good chairmen do not command, they serve. And this looks a lot more like command than serving, because you're not serving when you just reject points of order, especially good ones. One committeeman appearing by Zoom was not allowed to. That might actually be. There might actually be some legs on that one due to I think it's Article 11 in the state rules having to do with electronic meetings, and elections are actually supposed to be secret ballot a lot of the time, and you can't do secret ballot over. No, we have it in the rules. No secret ballots over Zoom. And the relevant Bingham County bylaws and state party rules are suspended as to down. Yeah, you can't suspend those things. There's other things you can suspend. Those aren't one of them. The grievance received by Bingham County did not state the name of the complaint, and for good reason. So, good number of days later, September 5 of last year, issued a letter to Bingham County precinct stating that neither were allowed for an election to fill an anticipated vacancy. Now, that's just something that we might want to change later, and there might be good reason to change it later. But as for right now, they don't. Anticipated vacancy. I like how that's worded there. Chair Moon announced that she would provide notice and schedule a meeting in September to elect blah blah blah. Chair Moon later scheduled a special meeting to fill on September 18th. See, what was I doing September 18th? Was that a Friday? Anyway, September 18, 2023. On September 14, Mr. Thompson, by letter of State Party First Man Dan Silver. Oh, yeah, you're kind of not doing a good thing when you're involving the first vice chair. Yeah, I do not have a high opinion of him. Chair Silver gave notice of the appeal. Okay, so that's actually part of the process, giving notice of the appeal, blah, 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 to avoid the down ballot election. On the same day, Thompson emailed Chair alerting her of his appeal. Thompson asked Chairwoman whether she intended to proceed with the meeting or wait for the appeal to take place. When Thompson did not receive a response, he and the executive committee of the Bingham County people on September 14th filed their original complaint in this lawsuit. Oh, so that was planned. Yeah. You're kind of not acting rightly when you do that all at once there. Filed their original to enjoin the state party from holding the September 18 meeting, permitting the Bingham County people to operate normally and requiring state party to afford the Bingham County people its appeal as granted by those rules. Well, okay, I mean, if you're just going blind in the situation without being informed of it, I see why the court would act that way. The temporary restraining order was issued the next day, apparently, and almost a month later, on October 10, the Bingham County people's request for a preliminary injunction was granted, and under that injunction order of the time, the state party is barred from calling any special meeting. Oh, okay. So they're just being a real jerk there. To elect until after the has run its course. Ah, okay. Well, we're now a bit past that now. But yeah. On November 7, the state party filed its motion for summary adjudication of its claims raised by the Bingham County People's lawsuit. Okay, so now we're going to get into a lot of the geeky things that I actually came here for. The relevant legal authorities, standard of review, objection to admissibility of affidavits under must be analyzed. The term affidavit. I think they're talking about that one dude's thing right here. So that's actually kind of boring. Affidavit refers to testimony when conceiving evidence supported to the court may only consider at trial. Relevant evidence is generally admissible at trial. Why are they talking about trial here? Irrelevant evidence is not admissible. Okay, I suppose they're getting somewhere with that. Evidence is relevant, and if it has a tendency to make a fact more or less probable, than it would be without. Okay. A court's determination of admissibility. Still recording, right? Yeah. Okay. We still. Yeah, we're still. Okay. A court's determination of admissibility of affidavit is accordingly must correctly perceive. Blah blah blah. Okay. There are a bunch of building blocks to this that they're getting at here. Standard review. Motion for if the pleadings, deposition, and admissions on file together with any affidavits show no genuine issue, it's from really fact and moving parties entitled to judgment, then summary judgment may be granted. Okay. And citing a lot of foundational stuff here. I think that's the word for it. Disputed facts are construed in favor of the mon rather than. Oh, okay, so yeah, if you construe all the facts in a certain way and it still doesn't have legs, then yeah, you would rule one way. I've heard a lot of law tubers explain that. Inferences that can be drawn in favor of our non-moving party. The party moving for settlement, in this case, the state party, has the burden of presenting admissible evidence showing that there is an absence of any genuine. Okay, so they have to say, hey, look, there's no reason why you should be moving forward here. You know, they're the ones that have to get there. Party against whose summary judgment is sought, the Bingham County people, cannot merely rest on its pleadings. When faced with supporting. Okay, so they're explaining how summary judgments work here. Okay. While the moving party must prove the absence of a genuine issue of material fact, the opposing cannot simply speculate. A mere scintilla of evidence is not enough to create a genuine factual issue. Yeah, Nick Rickea got mad at that particular phrase once. I'm forgetting why. Summary judgment is appropriate when the non-moving party cannot establish the essential elements of the claim. So why are we here then if I said it like that? Okay, well, let's continue on. If reasonable persons could reach different conclusions on material law, therefore must be denied. Okay, so if there's any room to wiggle, then yeah, they have to deny it. All right. Contract interpretation. Okay, this is more foundational stuff. The Idaho nonprofit. Okay, so here's where we start, at least for us. I'll just call it relevant law for now. The relevant law regulates the creation, governance, and dissolution of nonprofit corporations formed under state laws of Idaho. Corporate documents are equivalent to contracts. I didn't know that. So that's why they're talking about contracts. Corporate are among the members of an association. Okay, that makes a little bit more sense now. Therefore, the normal rules governing the interpretation of contracts apply to the interpretation of the association bylaws. Okay. Bylaws of a corporation are binding on its members. Oh, that's a problem for Bingham County. And it's almost like, when you used to see, like, in old pro wrestling, Steve Austin, the one that, is bald-headed from Texas, delivers stunners, hands out, chugs beers. He would hand you a beer and then immediately give you a Stone Cold Stunner. This is handing them the beer, and they were about to do a stunner on it. That's what this looks like. So, actions taken in violation of a corporation's bylaw are void. That I'm gonna need to know that later. It says footnote 91 there. Let's see, 91. I'm gonna have to. I'm gonna copy paste something. See, null and void. Let's see. Actions taken in violation of a corporation's bylaws are null and void. I'm writing something in another. Probably not showing what I'm typing at now. Good reason, but I'm gonna need to know that citation later for something coming up at the convention, probably. 91. It's Kremer versus Newman, 161 Idaho. Okay. I'm gonna want to know that later. I have some homework for myself later. All right, but let's continue on though. Statutory interpretation. Judicial interpretation of the statute begins with an examination of the statute's literal words. Okay. When a statutory language is when statutory language is plain and unambiguous, effect must be given to the legislative deliberate drafting. Oh, drafting decisions. I had to look at a lot of the stuff from the legislature of the time because that's that 1970, 1971, both regular and extraordinary sessions. With that one video I did, they're referencing the very same material that I've already gone down. This is interesting. Judicial construction is necessary only if statute is ambiguous, incomplete, absurd, or arguably in conflict with other laws. I don't think you're going to find any of that in this situation because I've already had to go down a few rabbit holes there. I've wanted to know about the case law regarding such things, but I don't have access to Westlaw. But they're They're giving me an in now. This is interesting. I didn't expect to find that in this. Statutory interpretation requires that the statute be viewed as a whole. Yeah, you got to view the whole thing. Statute, okay, and okay, well, okay, now it's getting kind of boring again. But the implied covenant of good faith and fair dealing, okay, that's another one of the things that they mentioned. I learned kind of implied fair dealing exists an area that are part of their obligation imposed by their agreement. This is going to be a problem for Victor Miller later. I'm just going to say it right now. It's going to be a problem for him. Because good faith and fair dealing is definitely not a Victor Miller thing. And he is blatantly ignored bylaws, state rules, and state code when it doesn't suit him. But we'll move on. Party violates the implied covenant of good faith and fair when it violates and notifies. Okay, so they're saying why breaking that kind of law is bad. There's a lot of Idaho code authorizes Idaho courts in appropriate situations. Okay, I might look at that law later. I think that's just the one that says the courts have power to do things. I think that's what that law is, if memory serves. Any person interested in a written contract whose rights, status, or may have a question. Likewise, any person interested in a written contract may obtain a declaration of rights, status, or other legal relations under the contract. I wonder what they're getting at there, if anything. Orders to show cause. Okay, this might be interesting. A person may petition the court for an order to show cause with verified complaint, blah, blah. Okay, this is a lot of how we got here, it looks like. If the court finds, blah, blah, blah. Okay. Now let's get down to the analysis, because that was a whole lot of how we're getting there and how we got here kind of stuff. The state party's objection to the... okay. I don't even know what that declaration is. I didn't even hear of it. It might have been mentioned to me at some point, but it just wasn't related to me that way, and so I have no idea what this even is. But I guess it was a statement made at some time in support of the Bingham County people. But whatever. The state party tersely objects to the declaration on the ground that it is not relevant on any of the issues. Yeah, that kind of happens. That kind of thing happens when you're mad that the chair is a woman. At oral argument, Bingham County people answered that the declaration supports its breach of covenant, blah, 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 by showing that the state parties withholding information, withholding of who signed the grievance, allowing time to run for giving notice to the general election was not a mistake or oversight, but a political strategy. No, it's not political strategy when you're trying to protect whistleblowers, you a-hole. The Hafen Declaration details a grievance filed against Gem County. Why are they mentioning Gem County? Regarding the procedures of electing a new chairman, according to Mr. Haven, the state party refused to provide the reasons why the election was allegedly improper until after the 30-day time period for okay. They had a weird election hiccup in Gem County. Okay. In this case, state party provided Bingham County people with a copy of the grievance 9 days before. Thus, the fact pattern attested to by Mr. Haven does not tend to make a fact more or less probable than it would without his testimony. Oh, they're quite literally saying the things that he said don't matter. Okay. Therefore, the Haven Declaration is not relevant to the state party's motion for yada yada and shall not be considered herein. That was a polite way of saying go away. Well, summary judgment as to Bingham County's people amended complaint shall be granted and denied in part. Oh, okay. This is interesting. The state party bases its motion for summary judgment largely upon the Bingham County's people's breach of contract. Nevertheless, the state party requests summary judgment on the merits of the case. Well, if they're going for gold and if they think they can get there, go ahead and try it. The Bingham County's amended complaint consists of four causes of action: breach of contract, breach of blah blah blah, all that stuff we've already said. Some of the Bingham County people's causes of action and request remedies for multiple state party or Bingham actions. Okay, a bunch of footnotes down there again. None of them seem to be really all that interesting. For clarity, the parties' arguments shall be addressed as arguments pertaining to the Bingham County's causes of blah 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 blah. Count 1, breach of contract. The Bingham County's first cause of action alleges that the state party breached its contract with by violating state party rules. Okay, they're kind of saying it backwards, but okay. To sustain a cause of action for yada yada, the Bingham County people must the existence of a contract. Well, they did show that. The breach of the contract didn't show that. Damages caused by the breach, they're on thin ice there. And the amount of those damages, yeah, you're not even getting to that part. The contract at issue is the state rules. And since the state rules represent a binding contract, the general factual allegations, the Bingham County, I'm just going to say Bingham now. Bingham claims that Chair Moon's refusal to cancel the September 18 meeting threatened to deprive Bingham of its appeal rights under state party rules. Well, no. She's trying to actually do you solid there. She's trying to do you fair there. But okay, whatever. The Bingham further claims. There's a weird. I wonder if that was even visible in the. No, it's okay. It's not visible on the thing, but there's a notification that I just got. I don't want to react to yet. The Bingham further claims that the Chairman's decision to void the election was unsupported by. Well, you maybe have there, but what's that subsection in the Article 12 of the judicial? It does give pretty broad powers with that, so you might or you might not have something there. The bylaws or Robert's Rules of Order. Why would Robert's Rules of Order have something for this? Weird. Count 1 of Bingham's amended complaint seeks the rights under to appeal decision. Well, that specific release was granted. Okay, so we're talking about things that have already happened. All right. Barring the state party from calling any special meeting to elect a new has run its full course. Okay. Also, in count 1, Bingham seeks the right under the state rules to have the July election of office recognized as a valid election. Well, you don't actually have that right if you didn't follow those rules. Thus, it must be determined whether Chair Moon violated state rules by declaring Bingham's July 20 election invalid. By motion of summary judgment, the state party supports Chair Moon's declaration because Bingham County failed to give proper notice. County chair wasn't vacant. These are the things that we've been talking about for a while now. Bingham bylaws cannot subvert Idaho law, and oh yeah, that's right, they can't because of that parliamentary authority thing that we read. I wonder if that's the footnote. Maybe, maybe not. Okay. Anyway, and failure to follow state party rules breach the Bingham's contract with the state party. Each of these allegations shall be addressed. Okay, I don't know that word. We're going to look up that word. seriatim. We're gonna look this up. We're gonna look this up right now. It means taking one subject after another in regular order, point by point. Okay, so they're going to get to it when they get to it. All right. Proper notice of chairman election. The state party argues that Bingham's position did not become vacant until August 1, the effective date of Craven's resignation. That's the way it should be, at least. After August 1, Chair assumed the duties of chairman was required to call a meeting. Process I've had to go through at least a few times now in different positions. When you have a vacant chair, you got to elect a new one, but only when you have a vacant chair. Since Mr. Townsend did not call a meeting, those details, state party asserts Chair Moon had a duty to call the meeting for the purposes of electing a new chair. Well, that's exactly right. At least that's my position on it. Let's keep going. Bingham County counters that Chair Craven's notice of chairmanship election was appropriately given because it was sent 7 days before. No, that's not how it works. And I think Dan Cravens even knows that's not how it works. And clearly contemplates the election of a chairman. No, there needs to be a vacancy. Anyway, in reply, the state party points out that nothing in Chairman Craven's notice mentioned down ballot elections that also took. Oh, I wasn't even thinking about that. Yeah, if there are other vacancies, you got to have the 30 days. And oh, they shot themselves in the foot. Okay. Well, state party notes the rules required Bingham County to hold a special meeting within 7 days' notice. In addition, Bingham County voted to suspend its bylaws in order to download blah 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 blah. It can't do that even. And Robert's Rules of Order even says that. Let's continue though. So Article 4, Section 9 of those rules. Oh yes, I'm very familiar with this block of text. It's the chair vacancy text. Similar rules apply to vacancies in the office of statement blah 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 blah. That chairperson is tasked with sending the notice for when vacancies occur and blah blah blah. Comparatively, the bylaws. They're even going into their own bylaws. Should a vacancy arise, the first advisory shall within 30 after giving 7 days notice call a meeting. Okay, so even their own bylaws ratting them out. Okay, so on July, I'm going to send an email, blah, 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 stating, as I've mentioned, my family and I are moving to Missouri. I plan to officially step down as the county chairman on August 1st, 2023. In order to help pave the way for a smooth transition, it would be best to elect new chairman at our meeting Thursday next week at 7 p.m. at the courthouse. The new chair will take office. You can't do that. Not without supporting bylaws. You can't do that. Voting by rule is limited to only precinct committeemen. That part is true. That's actually a pretty deep rule. Yeah, you can't. Alternates cannot vote on electing party officers. Well, that depends on how your bylaws are written. Those committeemen need to do so can participate via. No, they cannot. That breaks the electronic meetings part of the state rules. The committee may need to address other vacancies depending on who is elected. Yeah, after 30 days. Forwarded to all. Yeah. So there's a few things that Dan Cravens, I think, even knew was wrong in this, and yet he was just trying to put a task force on them anyway, which is really strange because everyone knows that they probably would have got identical results had they just followed procedure. Why was he trying to speed things along? It wasn't going to make it more smooth, obviously, by now. That's for sure. Secretary afforded to all members of blah blah blah. The actions by Chairman Cravens were certainly odd. This is the judge writing this. The actions by Chair Cravens were certainly odd. It appears from the record that Chair Cravens was interested in overseeing the election of his successor as well as other down ballot positions, despite clear rules and bylaws that the chair election must take place within 30 days from the date of the vacancy, within 7 days' notice given by the appropriate person. Moreover, under state party rules, the down ballot election also requires a special meeting within 30 of the vacancy upon. That's what the rule said. The court seems to be agreeing with a lot of a lot of my friends and myself on this issue. There's a dirty spot on my glasses. I'm trying to. That's good enough. At the July 20 meeting, prior to reaching agenda item number 8, you know what? Their agenda at the time might be in the supporting documentation. I'm not going to go find it. Filling expected chair and other positions as needed. Oh, you can't do that. You can't do the as needed part. You got to have the 30 days. 2 precinct committeemen suggested that a vote on a replacement would violate bylaws. Okay, what's this 148 footnote here? 148 candidate. Oh, okay, so it's some statement that was given before on all of this. All right, a clarification of the regulations was given. The regulations was not recorded in the meeting minutes. Well, that's interesting. Committeeman Josh Sorensen was informed that he was not allowed to vote because it was. Oh, okay, that's actually technically true because of the rules. Technically, but this whole thing was kind of wrong. Anyway, Committeeman Ryan moved to table the chair election. Was defeated by a majority vote. Moved to suspend the rules to elect. You can't do that. You know you can't do that. I think I've established that by now. The voting then proceeded to fill the positions of chairman, state committeeman, state youth committee, blah, 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 blah. Thus, Chair Cravens had plenty of notice that his actions did not conform to. Ooh. This starts the finger wagging now. He moved to suspend the rule for the purpose of carrying out elections rather than. Oh, they're proving that he knew better. They're proving that he knew better the other way. Oh, that's interesting. Okay, neither state rules nor the Bingham bylaws address their suspension for any purpose. Robert's Rules of Order. Okay. Robert's Rules of Order, which governs where not in conflict. Interesting way that they say that. In general, the constitutional laws of our doctrines. Okay, I recognize this text. This is about a third of the way through Robert's Rules. It's in this book. The term bylaws, as used in this book, is referred to. Okay, they include the whole thing. Footnote 157. 157 for Robert. 2.8. Oh, yep, that's the very text. I thought it was later on in the book, but let's see if I can. They're talking about that right there. Yeah, page 18 of the latest edition. Talking about that right there. Going back though, both the state party rules require any amendment to be considered on previous notice and yada yada. Thus, the state party rules and the bylaws fall within the definition of bylaws under the. Ooh, they're making sure that they can't get out of this. Good on the judge. Accordingly, the Bingham County did not have the authority to suspend either state party rule or Bingham bylaws at that time. Chair Cravens' July 13 message did not comply with state rules or for ooh, that dude is getting skewered. Chair position because it was not sent while the chair was vacant and was not sent by the vice chairman. Likewise, Chair Cravens did not give 7 days written notice of all the down ballot elections. Which is really interesting because if they had just handled these elections in due time, they probably would have got identical results. As for the substance of Craven's notice, neither the state party rules nor the bylaws define what constitutes proper notice. I'm not sure if that's actually correct, but I'm going to let that one go. Proper notice, they've been mentioning it this whole time. It's like the 7 days and 30 days and whatnot notice. According to Robert's rules, due notice need only briefly describe the substance of, okay. Talking about, alright. Yeah, we can skip past that. It's actually pretty dry language. The purport of a motion meeting to yada yada. In his notice, Chair Cravens, in order to help pave the way for a smooth transition, it would be best. Oh, they're italicizing that for some reason. Ooh, this might get interesting. To elect new chairman at our meeting Thursday as blah 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 at the courthouse. While the notice presents the election of the new chairman, at the July 20 meeting as its subject, preceding phrase "it would be best" muddies its intention. Ooh. Okay. Chair Cravens does not plainly state that the new chairman will be elected at the. Oh, really? He didn't even do that. That's interesting. Instead, he appears to offer the best option or to give a suggestion rather than actual notice. That's interesting. It's very interesting. Further, the email between Chair Cravens and Secretary Cannon is conversational in nature. That's interesting. Chair does not request the secretary to send its message, blah, 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 blah. The questionable clarity of of Craven's notices is of little import given the lack of vacancy in the office of chairman and the improper source of the notice. Oh, okay. The vacancy of the blah blah blah. The argument contends that that Bingham County failed to follow state party rules when conducting the election because there was no vacancy in the chair on that date. Bingham people declare that filing the chairmanship vacancy before it became effective was appropriate. No, it's not. But let's see what this footnote is. I'll just read that again. The Bingham County people declare that filing the chairmanship vacancy before it became effective was appropriate under Robert's Rules of Order, and it has a footnote here of 169. I already know that's crap, but, well, let's find out. 169. Oh, it's just some documentation earlier in the case. I'm not going to go find it. The Bingham County people add that under Robert's Rules of Order and Idaho law, county chairmen serve at the pleasure of a county central or until their successors are elected. Technically not true, but we'll find. Well, we'll keep going. Thus, they argue, Bingham County had every right to replace whenever they chose, regardless of its future. That's not true because they have these bylaws. But okay. Additionally, Bingham County tenders the Miller Declaration, wherein Ms. Miller opines the word "of" in both is not clear as to whether the No, it's actually kind of clear, but okay. whatever. Robert's rules are adopted by both state party rules and Bingham County bylaws. We're not inconsistent with yada yada yada, as we've already discussed. Thus, where provision is made for officer elections by law, by rule, and need not be consulted. Well, it's not exactly how I would put it, but this is the court. I'm just a parliamentarian. Under Idaho Code 34502. Oh, under 34502. Let's look that one up real quick. It's just 34502, right? Yes, okay. County Chairman. Oh, yes, okay, I know which one that they're talking about now. This is the one that further says, yeah, you got to do the things that are in the law, in the state, and in the state party rules. And there are certain things that the precinct committeemen get to do, and there are certain things that they must do. And yeah, this little section right here had a lot to do with my research last year with the whole Chalice meeting. But let's get back to this. So under precinct committeemen shall organize who shall all okay. Also, they're using the random part of 34502 to mean that the rules don't actually matter in this case. No, I don't think that's it. But let's see where the judge goes with this. If, however, the July 20 election was intended as a means to remove, I don't think that was. Oh, this is how he's coming at it. Okay. Intended as a means to remove Chair Cravens from office prior to the end of his 2-year term. I don't think they meant to explicitly remove him. I don't think they meant that. Then Bingham bylaws required a vote for any cause deemed just by them after due notice of a hearing. If and not only so not only was that not even it, but such a meeting to do that would have had to have had notice. Interesting. The record does not support a finding that the July 20 meeting was intended to consider and vote upon Chair Cravens' removal. Oh, that's interesting. I would not have thought of that. That's why I'm only a parliamentarian. Neither was notice given of or vote taken of. The court got them there. Instead, at the July 20 meeting, Chair Cravens gave a parting speech to the officers, precinct committeemen, and guests present. He was presented with a gift of thanks. No motion was made to remove him. Indeed, interesting. Indeed, it was apparently anticipated that Chair Cravens would remain in office until. Oh, so they even knew that. Okay. The phrase, at the pleasure of the county centerman, does not conflict with the bylaws, which provide for removal of county law upon due notice and a hearing. Oh, someone tried to play lawyer in that committee and got wrecked by this judge. Okay, let's keep going. Bingham County then argues that without an express prohibition in an organization, the future vacancy may be. No, that doesn't work like that. Okay. I'm trying to say that if the bylaws don't prohibit the vacancy thing, then it's just going to be filled before it becomes effective or something. In support, the Bingham County cites Robert's Rules of Order and an opinion from the American Institute of Parliamentarians. Why are they getting involved in a legal matter? That's interesting. In return, the state party states that Robert's Rules of Order governs only if there are not contrary provisions to state law or state party rules. Keep coming up. Yeah, they keep coming to that point. The Bingham bylaws adopt Robert's Rules of Order in all cases which they are applicable. Okay, so they even read the same thing we did just now with this other tab. The court was getting there. Okay, all right. They're went into the same place I did. In all cases which they are applicable, similarly, the state party points out, adopt the current condition of which they are applicable, and blah 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 blah. A bunch of things we've already gone over actually. The language of the state party rules, Article 4, Section 9, appears straightforward and unambiguous. Yeah, okay. I think this was cited just a little bit ago, the same text. We're going to move on. Thus, under the relevant Bingham County bylaw, a county chairman may be removed from an office prior to the expiration. Upon a chairman's removal, a vacancy is created, and blah, 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 blah. If a vacancy occurs for reasons other than removal, the same procedure applies. Oh, that's interesting. Although state party rules do not address removal of county committee officers, well, not directly, but if you look, there's certain things that will absolutely be relevant. Ask me how I know. Bingham County bylaws provide specific provisions which require with due notice. While Roner may not allow for the of a chairman-elect, such procedure conflicts with the clear and unambiguous mandate of the state party rules. Of that part we've already gone over. Okay. Moreover, if Ms. Miller asserts, as Ms. Miller asserts, Bingham County Bylaws, Article 3, Section 6D, allows for notice of special meeting, blah, 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 30 days. Oh, they're even going back to the text and saying, no, the thing that you're even citing is wrong. Says you're wrong. Governing bylaws as required. Oh, they're just going over all the reasons why Bingham is wrong. Thus, state party rules, Article 4, Section 9 does not offer an alternative before or after interpretation. If Bingham bylaws is given more than expansive reading, it conflicts with the clear language. Oh. That means Dan Craven's messed up in yet another way, and I'll show you what I mean if I can find it. There's this little part of the state party rules that I don't know if they're going to mention here, but it's Article 4. It's like Section 2 or 3. Let's see if I can pull up the right. Let's see. I'm live scrolling through all of this. Let's see. We need to get to Article 4. That's like Section 2 or 3. Okay, yeah, it's Section 3 of that same article that they're referencing. Section 3, the county chairman shall ensure the existence of set rules and bylaws for the county organization. These rules must be compatible with the election laws of the state of Idaho, and so it's the county chairman that is supposed to be making sure that everything's compatible with state rules. And he's very clearly not doing that because of this. Right here is given more passive reading, conflicts with the clear language of, y'all should have just had a vacancy and then reelect and then just did a chairman election. Y'all should have just done that. And now the court gets to point out all the reasons why you're wrong. Additionally, bylaws of governing rules of which are contracts must be read as a whole. You got to do the whole thing. They all got to mean something. You can't just ignore parts of it. Both state party rules and Bingham bylaws require that the notices must be given by the vice chairman. There might be a situation in which we'll require otherwise, so maybe we fix that particular part, actually. I'll talk that over with some friends. The improper... Oh, so they're even just prefacing it now as the improper July 20 meeting now at this point. I don't think they even declared it improper by this point, but they're just saying it's improper now. I love that. The improper meeting notice was given by blah, blah, blah. Okay. Chairman position. Oh, yeah, that's right. They tried to say chairman-elect was a position when it's not. The state party anticipates that the Bingham County will rely upon its bylaws, which define officers. Okay, so they're saying that it's defining officers and yada yada yada. We had to make a change to District 17's officer bylaws for a very specific reason. Last year, in fact, to infer that a chairman-elect position could be added to the town. So yeah, you could potentially add such a position to the bylaws, but you need to amend the bylaws in order to do that. The state party reasons that simply bestowing a chairman-elect title upon a committee member does not give that person the power to function as a county chairman without being elected to that position. I need to drink something really quick. The Bingham County people rejoined that the state party's officer-elect discussion is a straw man argument. Well, no, it's not. It's not. You're relying upon chairman-elect to be a thing. It is not a thing. That's not a straw man argument. It's quite literally the opposition saying that is not a thing. Because Bingham County never advanced to the creation of a chairman-elect position. You do realize that you're calling yourselves liars by saying this, this last part, Bingham. You do realize that, right? Anyway, we're going to move on. Accordingly, no further consideration shall be given to state parties anticipating chairman. Also, that's the in part of it. Oh, okay. Substantial compliance with state party rules, it says right here. Well, let's see where they're going with this. The state party verse that since Vice Chair Thompson did not call and hold the required special blah blah blah, the July 20 election was, as determined by Chairman, invalid. If July 20 election was invalid, then Bingham County fails to raise a material issue effect as to its remaining. Oh, that's right. Yeah, they can't claim breach of contract if the language is actually pretty clear. In its opposition, Bingham County argues that it substantially complied with. No, they didn't. In fact, they were later trying to say that they don't have to comply with the rules at all. Interesting. Yeah. See, the problem with these people, as well as the people defending them, like Trent Clark and Greg Chaney, is that people actually heard what they said. And anyway, in its opposition, Bingham County argues that it substantially complied with state party rules because none of those Bingham County members who were absent, meaning signed the grievance. How would they know that? And those who did sign the grievance were not aggrieved parties. Tread carefully because you might step in something here. The Bingham County members who signed the grievance were present at the meeting. 203. Oh, this is where Cheney comes in. Okay. But this is footnote 203. See, I'm tempted to go find whatever this document is, but no. Okay, so 203. The Bingham County takes the position that none of those who signed the grievance were negatively affected by the election. Well, that's a bold claim to make, and you're almost certainly always wrong in making such a statement. Yeah, never say something like that. But okay, we're not negatively affected. Okay, whatever. Okay, that's just dumb. It's also language on par with an abuser such as Greg Chaney. It's like, no, you weren't even negatively affected. let's say because they were not voting members. Well, they were. Okay, so you okay? If you're trying to say with A right there that the Republican voters of your county don't have an interest in what's going on, is that what you're trying to claim there? B, they were not present and voted, or if even if all four absent community persons voted against, they're even admitting that there would have been identical results. They're even admitting that in footnote 204. Okay then. Oh man, this has been going on for way too long. I thought I was going to be able to knock this out quickly. In Perry, the state party avers that those who signed the grievance had legal right to expect an election in compliance with. Yeah, this is the reason why you don't say that. Well, one of the reasons. Okay, substantial performance of a contract is a defense against for is a defense, but in order to rescind a contract, court must find that one of the parties committed to which is blah 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 blah. However, there is no material breach of contract where a party substantially performs. Substantial performance is which, despite deviation from other, provides. Okay, the Bingham County people, by their lawsuit, does not seek to rescind its contract with. Okay. Instead, Bingham County seeks validation of. Yeah, fat chance. Okay, they want validation of their bad election. Okay, well that's not going to happen. The bylaws of the corporation are equivalent to contracts. Members and associate are binding on the actions taken in violation are void. I'm going to need to. Yeah. Anyway, Bingham County's membership had a contractual right to rely upon the rules and procedures as set forth in yada yada. Where an organization's bylaws set forth a clear procedure in filling a leadership vacancy, those procedures must be followed in order for a court to validate the organization's action. So you got to follow rules in order for us to back you up. Okay, that's what the court is saying here. Furthermore, even if the doctrine of substantial performance is applied, the set of facts did not substantially comply. Oh, they're not even saying that's really. The Bingham County people did not substantially comply with the rules for filling officer vacancies. The actions taken by Cravens, together with the objections raised, leave no doubt that Chair Cravens willfully ignored state law. And all the other stuff too, to determine to the detriment of the Bingham County officers and members left to untangle the situation he created. Oof. The Bingham County people complain that Chair Moon withheld information about what is challenged until the 30-day final. Blah 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 blah. Well, that's kind of not a thing, but okay. However, on August 21, when the Bingham County people received the contents of the grievance, the ship could have been righted, so to speak, as Mr. Thompson had, as acting chair, given notice of a special meeting to elect a new chairman and schedule that meeting on or before August 30. The grievance explicitly states that the office of the chair was not vacant on that day. I've been beating that drum a lot. Thus, Bingham County had noticed that the grievance relied upon state party rules, Article 4, Section 9, and yada yada yada. It specifically complained that the chair position was not vacant on the election date. Had Mr. Thompson, on August 21, sent out notice of a special meeting with formally electing new chairman, the necessity of formal action by Chair Moon, which precipitated the lawsuit, would have become unnecessary. So they literally said, had you obeyed the rules, none of this would need to happen. The Bingham County people also rely upon a waiver as a means of validating the flawed election. The Bingham County people, the plain language of Robert's Rules of Order. Well, I would I would say that a lot of the rules, a lot of the text of, a lot of the language of Robert's rules is definitely not plain language. And the Miller Declaration as its authority. Well, in her declaration, Ms. Miller states that any other defects in July 2023 the officer election were waived by failing to timely raise a point of order. That's not how that works. If you're saying that somebody doesn't complain about it in time at the meeting in a certain way, then they don't get to raise any complaint about it at all. No, it doesn't work that way. And you know what? I'm willing to bet that this Miss Miller, whoever she is, probably knows that too. A point of order is a means of calling upon the chairman for ruling and enforcement of regular rules. You're half right there, but whatever. There's a nitpicky part of that which I can latch onto, but I won't. It is appropriately utilized when a member thinks that the rules of the assembly are being violated. Okay. Ms. Miller opines that an election can only be contested by raising a point of order when the vote. That's not even true. But according to Secretary Cannon's notes, two members suggested violation of the bylaws if voting for the president were to occur at this meeting. Well, they ended up being correct. According to the grievance, points of order were made, and before nominations were made, Rhonda Cheatham stood and read the Idaho GOP rules and the Bingham County bylaws, blah, blah, blah. The chair stated that he rejected the point of order improperly. Good chairmen don't command, they serve. And Dan Cravens wasn't serving there. Okay, so that footnote is just some other documents in the case I'm not going to go find. On to Robert's Rules. Okay, bunch of dry things that we don't need to go over. In terms of elections, a point of order is not waived if the election fell within any of the exceptions to the timeliness requirement. In such cases, a point of order can be made at any time. It continues to blah, 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 blah. Here, the July 20 election occurred in violation of Idaho Republican Party rules, Bingham bylaws, and I'm going to check something. Yeah, okay, it's still going. Never mind. A formal motion was then made to table the voting new chairman. The majority of the members present voted against the motion. Interesting. That means that also suggests, as we've been stating for quite a while now, that you would have got identical results if this sentence happened. The majority of the members present voted against the motion. Or whatever. Since the election violated the state party rules and the bylaws, a waiver of the point of order or the objection to the judgment has not been shown. Well, that's interesting. For the foregoing reason, Chairman did not violate state party rules by declaring invalid. And that's what you should do. You should declare it invalid rather than make it an election void. There's a difference there, and looks like we managed to not trip over it. No material issue of fact remains in the trial, blah, blah, blah. Therefore, count one shall be summarily adjudicated in favor. Count two, a breach of the covenant of good faith and fair dealing. Oh. I've been going for quite a while now. Let's see, how much recording? I've been doing this for an hour and a half. Okay, you know what? I'm just going to skip to the end of whatever this is. The Bingham County election was invalid as set forth above. Okay, there you go. Therefore, the Bingham County's first ground for a breach of covenant does not reign a material issue of fact. Okay, so they're already gone. All right, with regard to Bingham County's allegations that the state deployed deception and conspiracy in planning, no, they didn't, and that the state party failed to be transparent about the source of the grievance. The state party have not argued such claims lack material fact, and therefore the state party's motion for summary judgment as it pertains is denied. Oh, that's not the way I would have gone, but I'm going to make sure I understand this right. Therefore, the state party's motion for summary judgment as it pertains to count two shall be denied. Oh, okay, you can't win them all, but let's get the declaratory judgment part now. Under its third cause of action, Bingham County requests declaratory judgment that Bingham County performed under state party rules sufficiently to validate the blah blah blah. Well, we can already kind of determine no, they didn't. But election as set forth, the Bingham County people did not comply state party rules sufficiently to validate. Okay. The Bingham County further requests declaratory judgment that yada yada yada. In response, Bingham County maintains that the grievance was invalid and blah 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 blah. Oh, great. We're getting into invalid grievance. All right. According to Bingham County Chairman's investigative function was never triggered because the grievance was invalid. How do you even arrive there? Okay, fine. Specifically, Bingham County points that not all 5 persons who signed the grievance were present at the July 20 meeting. Oh, so they were told who was okay. The 4 voting members who signed the grievance voted in the election. One of the signers was a non-voting member. Bingham County concludes that none of the signers deprived of any legal right. In rebuttal, State Party explains that the signers of the grievance were aggrieved by the Bingham County's failure to hold an election. Okay, this is gonna Chairman's authority to hold a night is not triggered. The State Party maintains under state law, Chairman had a duty to call because it was not properly. Okay. Oh, and 502. There's that. There's that law again. Given the okay, let's start with this part then. Given Bingham's failure to comply with state rules, the election was void. Okay. I've been going at this for way too long. And Son Chair Moon had authority. Okay. The state party's authority to void the election in this complaint and blah 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 under state party rules. A party agreed with them may file a complaint with the state chairman. Under investigation of the complaint, state chair is required effective amount of the opportunity to be heard. I believe that they were heard. So, and then must rule on the complaint and issue appropriate order. Do not delineate specific order, sanction, or remedies available. Okay. That's left quite open right here, and I think that was on purpose if memory serves. However, under state common law, where an organization takes action in violation of its own bylaws, such action is void. If, in the state party grievance process, a chairperson finds that certain actions were taken by a county organization in violation, then by law, such actions are void. Consequently, the state chair has the authority to declare a county action void. Oh, that's a matter of law now. I'm going to save that. I'm gonna need that later. Based upon the foregoing reasoning, count 3 of being an amended complaint shall be summarily adjudicated in the state party's favor. Okay. Count 4, order to show cause and its final cause of action being a request, an order requiring the Republican Party to reveal the name of blah 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 blah. Oh, they want to unmask the whistleblowers here. It appears that this request was resolved in discovery when state party provided all of that information. I wouldn't have, but you know what? Probably the lawyers had a good reason for it. Who signed the grievance and does not complain, that count remains unresolved. Okay, for the reasons shall be summarily in favor of. Okay, conclusions of law. Here we go. Based on the above findings and analyses, the following conclusions are appropriate. The Hayfin Declaration is not relevant. The state party has shown the absence of material fact regarding. Okay, so Bingham didn't back up their lawsuit. State party has not shown the absence of material fact. Okay, regarding the state party has shown the absence of material regarding request for declaratory judgment. The state party has shown absence of material fact regarding Bingham's request for a show cause order requiring the state party to reveal the names of those who filed grievance. Okay, now we're getting to the order part. Accordingly, the state party's motion for state summary judgment is granted in part and denied in part. The Bingham County people shall take nothing by its breach of contract request for a declaratory judgment and request for that's interesting. The Bingham County's remaining breach of covenant and good faith dealing remains on this court. Oh, okay, so there's a little bit of business left after all this time. Okay, and here's all the service and yada yada yada. Alright, so it looks like the judge mostly sided with state party on this, as it was expected, at least as far as the law is concerned. Now, I don't think I actually spelled it out before, but the judge is known to be a very swampy person, as he is a brother to one Mike Simpson. So there you go. Interesting. So it looks like now it's entirely possible that the Bingham County people will appeal this ruling by the judge, but I don't think that would be smart. But they've done a lot of dumb things already to get to this point, so who knows? Looks like it's at least a good day for the rule of law. At least there's that. I'm going to go to bed, and I'm probably going to upload this in the morning. I'm going to transition to potato before closing out. Y'all have a good night.